Is chairman of the International Property IT Infrastructure Group at the international law firm of Greenberg and Traurig. And as you can see, they have a considerable number of offices here. It's quite a large law firm in the United States and increasingly international. She was selected by the Daily Journal as one of the top 30 intellectual property lawyers in California in 2005. And for those of you who are familiar with the United States, you'll know that California has been the center of much of the intellectual property and technology growth, not only in the United States, but across the planet. So that I think that her expertise and background is quite extraordinary, and it's a distinct privilege for us to have her here. She authored a book, The Open Source Alternative, Understanding Risks and Leveraging Opportunities, which was published by Wiley & Sons in February of 2008. So obviously she's been not only practicing law, but also helping the rest of us to make sense of what is a very difficult subject. Heather is a graduate of Yale University and the University of California School of Law at Berkeley. She's truly a Renaissance individual, and I think that this may provide inspiration for all of you. Most of us generally think of lawyers as being very intense, focused individuals, and of course many are. But I think Heather's background is a testament to the fact that creativity in your career and diversity can be a central aspect of how you decide to lead your professional life. She started her professional career as a musician, as a singer, and needless to say, transitioning, you don't think of too many. I can't imagine Britney Spears as a lawyer, but nevertheless, the possibility, I guess, always exists. She then spent some time as a computer programmer, and then completed her law degree, as I said, at Berkeley, and went on to a very distinguished career. So with that introduction, I'd like to welcome Heather to AUK. Heather?
Thanks, Bill. I think I won't use the microphone, but if you can't hear me, please let me know. So I'll explain first a little bit about who I am and what I do, so you understand whenever anyone tells you something, you should consider what their viewpoint is, so that you understand why they hold the views they do, and also so that you understand what I do in case you have questions that either have to do with the topic that I'm talking about, or other questions you think that I might be able to answer for you about technology in the United States and law in the United States. Please feel free to ask. Also, during this presentation, if you have a question, feel free to interrupt me, because I want to make sure that you get the information that you're interested in having. So what I do as a lawyer, I don't go to court, I don't argue in front of judges. What I do is I'm a business lawyer, and my clients are technology clients, a lot of them in the software industry, but all over the technology industry. What I do for them is I negotiate commercial deals for them. And so sometimes this is called licensing transactions, and the reason it's called licensing is that a lot of the assets of technology businesses are intellectual property assets. And a licensing is the type of transaction you do with intellectual property. So most of you have, you've got a computer, you've seen a license agreement where you've been asked to agree to the terms of that license agreement. That's the kind of agreement I do, although most of what I do is agreements between big companies, not so much with a consumer like you would see on your laptop. So I negotiate agreements, and I write agreements, and I review agreements, and I advise my clients on intellectual property issues and issues about the technology business. My clients are sometimes very small companies, sometimes a couple of engineers who have started a business, and sometimes they're very, very large companies. So I work with people all over the spectrum. Now what I'm going to talk about today is patents, and I picked that because first, it's it's a very topical area. In the United States, there's a lot of controversy about patents, and we'll talk about what that controversy is, because it does bear upon the policy questions for the rest of the world as well. But also, patents are an area that most people, even lawyers, don't understand very well, so I thought it would be useful to explain how they work. Okay, so first we want to know what a patent is. By the way, the word patent, in English, you probably already know. If you use that word on its own without referring to intellectual property, what it means is something that is available for people to see. So you use the word patent not only in this context, but as an adjective to mean freely available. What that comes from is that when you file for a patent, you have to actually tell the world what your invention is, and we'll talk about that some more in a moment. But the main thing to understand, and if there's one thing that you learned today in this talk, is that a patent it's the right to exclude people from doing something. So if I have a patent on an invention, then what I can do is I can use the force of law to stop other people from practicing that invention. Because it's the right to exclude, we sometimes call it a negative right. In other words, that doesn't mean I have the right to do anything. It just means that I have the right to stop you from doing something. And that is the nature of patents, and that's the thing about patents that most people don't understand. So the fact that you might have a patent issued in your name, it doesn't necessarily mean you have the right to make a product. It only means that you have the right to control that invention, and if you want to practice it, it's okay, but if other people practice it, then you can use the legal system to make them stop or to get money from them. In order to get a patent in the United States and almost everywhere else, you have to actually go to the government. In the United States, it's called the Patent and Trademark Office. And you make an application in which you describe your invention. You say to the government, I would like a patent issued on this. And if you're successful, the government will grant you a patent, and this is what one looks like, although people don't consider what it looks like very important. This here is an example of a drawing. Most patents have drawings to explain the invention, so that's what one looks like. The examination process, as I said, you make an application, you write an application. There's an examiner in the patent office who looks at the application and decides whether you should get a patent or not. And only at the end of that process do you get that patent and the right to exclude others that I've talked about. Okay, there are some basic requirements for patentability, and these are true in the United States, but also more or less true in most places. First of all, your invention, which is what you're getting the patent on, it has to be new. And the idea of something being new is called novelty in patent law. But actually, that's a fairly easy requirement to meet. It just has to be something that someone hasn't done before. The really difficult requirement about getting a patent is the idea of it not being obvious. And what obvious means is that even though your invention is new, it might have been an obvious or clear thing to do to someone who is knowledgeable in the field. So, for instance, if I have a microphone and there's a little switch on it that goes back and forth to turn it on and off. And if I decide that instead of going this way, the switch should go this way for some reason, that would probably be obvious, because it's just not that big of a difference, right? And most people who could make the switch go this way could make it go this way as well, because they would be knowledgeable about how to make a microphone. But if, for instance, instead of having this kind of switch, the switch were entirely different, Like, for instance, I